Passage number 27. The facts necessitated for the disposal of the instant writ petition are that Muhammad Iqbal and Muhammad Akram, respondents number 1 and 2, filed application under section 14 of the Arbitration Act 1940 against the present petitioners with the prayer that the arbitration award dated 27th March 1997 announced by Mr. Liaquat Ali Chattha, magistrate, be made rule of court while passing a decree in this regard. Full stop. Brief facts as narrated in the said application filed by respondents number 1 and 2 are that a dispute had arisen regarding a plot measuring 15 marlas, and for the resolution of the same the parties agreed to appoint Mr. Liaquat Ali Chattha, magistrate, respondent number 3, as arbitrator, while agreements references dated 21st March 1997 and 27 March 1996 that the arbitrator, after hearing the parties, announced the award on 27th March 1997, which should be made rule of court. Full stop. The said application was contested by the petitioners with the assertion that the arbitrator, being magistrate, had got registered a false criminal case on behalf of respondents number 1 and 2 against petition number 1 and others, which was cancelled thereafter, being baseless, and that the agreement for reference being forged was ineffective upon the rights of the petitioners. Full stop. The learned trial court captured the disputed area of fact by framing the issues. Full stop. Both the parties adduced their evidence in pros and cons before the learned trial court, who, after appreciating the evidence available on file, decided issues number 6 and 7 in favor of respondents and against the petitioners, while accepting the application filed by respondents number 1 and 2 under section 14 of the Arbitration Act 1940 and award dated 27 March 1996 was made rule of court by the order dated 2 February 2001. Full stop. Feeling dissatisfied, the present petitioners preferred a revision before the learned lower revisional court, who dismissed the same void order dated 17th July 2003. Hence, this writ petition. Full stop. Learned counsel for the petitioners has argued that the impugned orders passed by both the learned courts below are against the law and facts, that the alleged agreement for reference was illegal, being based on fraud and coercion, which was not signed by all the parties to be affected. Therefore, the agreement for reference was not in existence in the eyes of law, that the failure to comply with the mandatory provisions of section 17 and non-maintainable, that the alleged arbitrator, Mr. Liaquat Ali Chattha, magistrate, was a biased person who got registered a criminal case against the petitioners, but the said fact has not been considered by both the learned courts below, that the arbitrator had acted beyond its jurisdiction, that the alleged agreement reference for the appointment of arbitrator was alleged to be executed on 27 March 1996, whereas on the same day the disputed award was announced by the arbitrator, respondent number 3, that the arbitrator had committed misconduct and passed an ex parte award without hearing the petitioners. Full stop. He lastly prayed for the acceptance of the instant writ petition and setting aside of the impugned orders passed by the learned courts below. Full stop. This para has been dictated by Kamran, working as PA in Civil Secretariat Lahore, as well as Principal Ajmair Shorthand and Computer College, Shahdara.